Namaste and greetings to our esteemed guest speaker, all the participants in today's International Virtual Summer School of 2025, organized by Nivaran, Mediators of Supreme Court of India. Today, we are on the first day of this summer school. Through these forthcoming 10-day-long in-depth deliberations by our esteemed guest speakers and also through the thought-provoking questions from our participants, it will be an enriching learning experience for all our participants. I, Sangeeta Mehrotra, is the host of today's session. I have been an accredited mediator since last 14 years after successfully completed more than 250 hours of mediation training under many national and international training providers. I immensely enjoy working as a resolutionary and have the good fortune to bring happiness in many disputants' lives through the process of mediation and conciliation. I am humbled being chosen by Nivaran to host this session where our today's speaker will give us a peek to the wonderful world of mediation, guiding us through its principles, practices, and powerful impact in resolving conflicts. Get ready to explore how mediation fosters understanding, builds bridges, and transforms disputes into opportunities for connection and growth. The concept of mediation is not new. It has deep historical roots in various cultures. Over time, as legal systems became more formalized and adversarial, mediation took a backseat. However, with the growing complexity and backlog of court cases, mediation has regained prominence globally as a part of the broader ADR movement. Here in India also, we are in the middle of this nationwide campaign, Mediation for the Nation, that has placed mediation in the center stage of our justice delivery system. Our honored guest speaker today is Diana Asonaba Dapaah. She is a legal practitioner called to both the Ghana and New York bar. She is an immediate past Deputy Attorney General and Minister for Justice of the Republic of Ghana. She is also the Vice President of the Ghana ADR Hub, an ADR training and service provider in Ghana. Diana is a lecturer in law at the Ghana Institute of Management and Public Administration, short form is GIMPA, teaching alternative dispute resolution, that is ADR, corporate law and governance, public international law, and human rights law. Diana introduced and developed the ADR course at GIMPA. She is a World Bank certified trainer in corporate governance and also in human rights and ADR. She has trained lawyers and judges in Ghana, Sierra Leone, and Liberia. Diana is a partner of the prestigious law firm Sam Okudzeto and Associates in Ghana. Diana shall speak for 30 flexible minutes, which will be followed by Q&A sessions for another 20 more minutes. Participants could post their questions in the chat box, please. This is my request. I will, or any of our Nivaran members or anybody, they can pick up those questions and will request Diana to respond. Nivaran meticulously observes time for which Honorable Chief Justice of India has praised the organizers yesterday. So we will take up the questions that come to us before the Q&A session starts. I urge our participants to make the best of this session. So here I welcome Diana to take the floor. Diana, the floor is yours.
Right, thank you very much, Sangeeta. That's a very kind introduction. And the way you mentioned my middle name, a lot of people struggle with it. So it appeared to me already Ghanaian. So thank you for the very kind introduction. And I mean, I'm very happy to be part once again of the Nivaran training. I think the last time I was here was 2023. And being the first presenter, I think my duty here today is to tease your interest. You really get out your interest on mediation. But I'm very happy because you being here is, for me, is an indication of some strong inclination of your interest already. So I only have to sustain that interest throughout. Let me quickly share my PowerPoint slides with you. Yes. Sangeeta, are you able to see my slides?
Yes.
Oh, right. So my presentation is on the theme historical perspectives of mediation and introduction to mediation. And so we're going to do some very broad engagement and appreciation of what mediation is all about. I hope to be guided by the outline on your screen, which is to start off with an introduction to mediation. We're then going to look at various definitions of mediation. And at that point, you'll find out that mediation, the virtues, the principles of mediation are more similar than they are different, even with the different jurisdictions that we have. And that is why this Nivaran training is imperative, and you find different trainers or presenters from across different jurisdictions. It tells you the similarity of mediation and why some of us continue to advocate for this consistent general system of dispute resolution, which among attributes include that there will be accessibility to justice and, of course, expedition to justice. I'll take you again briefly through the historical perspective of mediation, and then we're going to look at the process of mediation. We'll also then look at the differences between mediation and other forms of alternative dispute resolution. We also look at the differences between mediation and litigation. Of course, as an advocate of ADR, particularly mediation, I'm also going to end on that strong note by making a case why there's the need for us to patronize and encourage mediation by basically focusing on what has been the lacuna and the disadvantages of adversarial dispute resolution, encouraging us to consider strongly other alternative dispute resolution. I think, Sangeeta, you made a very strong point even in the introduction when you mentioned that mediation has always been one of the default processes of dispute resolution. We're going to talk more about it. And that is why some people have argued that when we talk of ADR, why are we saying that is an alternative to litigation? In fact, litigation is rather the alternative to the other processes like mediation, because where I'm coming from, culturally dynamic country, almost the different tribes that we have in Ghana, one thing was common, that in pre-colonial times, in times immemorial, the way we resolve dispute was, in fact, these very things that we are now bringing back to the front burner. So I'll come back to that. So introduction to mediation. Mediation is, in fact, a process, an ADR process. And by ADR, the acronym ADR is Alternative Dispute Resolution. And there are a number of these ADR processes, and one of them is mediation. There are others called arbitration. In fact, in Ghana, we even have what we call customary arbitration. And one of the attributes of ADR is its malleability and the party autonomy bit, where that parties can design whatever system they want to use to resolve their dispute. And that's why we call it alternative dispute resolution. So there are other forms and other hybrids of alternative dispute resolution that have come up, like MEDAP, some rent-a-judge, etc., etc. Because again, the scenario is made using the hospital example. And I'll talk more about it because what we call the Wolf reforms actually explains this even much more. The scenario is given, like the hospital setting, that if you go to the hospital, if you have an ear problem, you go and see the ENT specialist. If it is about your child, you go to the pediatrician. If it is about childbirth, delivery, and anything related to that, you go and see the gynecologist. If it is about your skin, your eye, there are different experts that you go and see. So why is it the case that when there is a dispute, there's only one mode, which is litigation? It just doesn't make sense. There should be different rooms, multi-doors, for us to explore, because not one size will fit all. There are different expertise, different rooms, different resolution framework for different kind of disputes. And that for me has been one of the advocacy for promoting alternative dispute resolution. Again, I remind you that some of us actually believe that litigation is actually the alternative to these other ADR processes. So mediation is one of such ADR processes because not all types of disputes are fit for resolution through the adversarial system. There are some for purposes of preserving relationship and other community interests. You want to look for some other non-adversarial ADR processes like mediation. So what is mediation? And again, this definition will become important when we look at mediation, the differences between mediation and other types of even ADR like arbitration, and we also compare it with litigation. So generally, mediation is a type of dispute resolution which involves the use of a third neutral party called the mediator who assists. And here I would want us to underline a few things and go out there and search. You will find out that these things, these terms that I want you to underline are the same wherever you find yourself, no matter the jurisdiction. So it's the use of a third neutral party called the mediator who assists the parties to negotiate a mutually beneficial agreement to their dispute. I've seen other definitions that says that, look, mediation is an extension of the negotiation process. They are unable to do, they may invite who comes in. So all that third party called the mediator does is to help with the negotiation process. He doesn't take over the process.
I think there is a problem, technical glitch. Can we do something about it from here? Anybody can, Santan, if you have Diana's contact number, you can message. Yeah, thank you.
Thank you very much. Sorry for this glitch. I lost you at a point. I'll make sure to make up for the time. I think I need permission to be able to share my slides. Again, it says sharing is not turned on.
Is that
right?
okay?
So I said, well, yeah, thank you. It's working now. I said, let's try and look at some definitions of mediation. So I think I tormented Santan for your Mediation Act. I found out that there's a new Mediation Act in India called the Mediation Act of 2023, the number 32 of 2023. And it defines mediation as includes a process, whether referred to by the expression mediation, pre-litigation mediation, online mediation, community mediation, conciliation, or an expression of similar import, whereby the parties attempt to reach an amicable settlement of their dispute with the assistance of a third person referred to as a mediator who does not have the authority to impose a settlement upon the parties. Again, we find the same attributes. There's a third party called a mediator. Unlike what we know in litigation as a judge, that third party does not impose a settlement or decision on the parties. We also see that it's the parties themselves that attempt to reach an amicable settlement. So I said, okay, let's compare it to Ghana's definition of mediation. We find it in the Alternative Dispute Resolution Act of Ghana 2010, Act 798. That also defines mediation as a non-binding process in which the parties discuss their own dispute with an impartial person who assists them to reach a resolution. It goes on to define a mediator as that third neutral party who helps the parties to resolve their own dispute. So very similar. Again, you can go on and other definitions like what we have in what has become known as the Singapore Convention, or the UN, some people like to call it the New York Convention on Mediation, because you have the New York Convention for arbitral awards, and then this Singapore Convention, the full name being the UN Convention on Settlement of International Agreements Settled from Mediation. Again, the same thing is the parties themselves who own the process. They own the dispute. They fashion out their own settlement only with the assistance of that third neutral party called the mediator. Now, again, back to the history of mediation, which I started. And I believe if the research will show that no matter the jurisdiction, we're going to look at it, whether in India, whether in China, whether in the US, in various African countries, in fact, mediation and the other forms of ADR processes are in fact the default dispute resolution mechanisms that we've known. Until for African countries and most other countries, there was colonization and formalization of litigation as a dispute resolution mechanism. So you look at the history, the various books on history of mediation, and you find that ancient civilizations, even including India, like in Greece, China, all used informal mediation as part of community-based dispute resolution. In fact, in Africa, customary law, you would usually, and I believe it's the same for a number of jurisdictions, you usually have very respected elders who would often mediate conflicts within tribes or communities. And that is why sometimes some Africans argue that, in fact, ADR should actually be called African Dispute Resolution. Others also say that it is not an alternative. In fact, ADR should be referred to as appropriate dispute resolution, because it looks out for an appropriate form, an appropriate expertise, an appropriate dispute system for resolving particular disputes. Now, again, if you trace the history, again, from the religious perspective, you find out, be it Christianity, whatever type of religion there was always that use of mediation-like processes, primarily for holding the close-knit nature of the community, whether it's a religious community or a tribal community that existed at that particular time. And so the use of mediation to resolve disputes is not a new phenomenon in the US. In the US, there's evidence that, a lot of groups within the US system, the Chinese Jewish communities, or had various variants of mediation, particularly to resolve organized labor disputes in the US. And so the history will show that, particularly in the 1960s and 1980s, the whole prominence of civil rights movement also then brought back, like Sangeeta said, mediation was taken to the back burners like most ADR processes, particularly when there was colonization and then the formalization, the introduction and formalization of introduction. But it picked up again somewhere in the 1960s and 1980s, particularly with civil rights movements, where then there was community mediation centers that were established to resolve neighborhood landlord-tenant disputes. And of course, these were also supported by a number of grassroots. Then we see some institutionalization of mediation and expansion of mediation around the 1960s and 80s, where courts then began experimenting with mediation to relieve the case backlogs. Of course, the case backlog is one thing that we continue to suffer even till now. That is why it's more imperative now for us to explore other means of resolving dispute, because justice must not only be done, but must be done expeditiously. And anybody in dispute is looking for the quickest and much more amiable way of resolving the disputes than they are interested in the litigious way and the cost associated with it. Of course, again, there was a huge global discussion emanating from what we call the Pounds Conference in 1975, where a lot of scholars and stakeholders of the justice delivery system met in the US and started questioning that why are we using litigation as one door for all dispute resolution? When it's family matters, is litigation. When it's commercial matter, is litigation. When it's criminal, it's litigation. When it is oil and whatever it was litigation. And it didn't appear appropriate to some of the solutions that were coming out. And of course, the backlog, the delays associated with litigation was also one of the priorities for the movement and the advocacy to look at other means of dispute resolution. And so the Pounds Conference, again, triggered it, the Wolf reform, or also one of the things that let's look at having a multi-door system of resolving disputes. And we see, again, ADR, including mediation, being more globalized and professionalized between the 1990s and 2000s, where mediation then goes global. We have both systems of law, both the common law and civil law system, in fact, encouraging the use of ADR in civil cases. In fact, it started with integrating it into family and civil justice system, and then gradually mediation and ADR in general began to get that institutional support that is needed. We even had the United Banks, UN, World Bank, and even WTO, World Trade Organization, who all included mediation in their dispute resolutions. Other institutions like ICC, LCI, of course, NIVARA, and other institutions then also began to look at ways of, coming up with a system that is appropriate and suitable for the different kinds of resolution. And so now you find that mediation is playing a very top role. Again, I'll explain why when we look at the differences between mediation and arbitration, even though arbitration is also one of the ADR processes. So now you have a system where mediation is now entrenched as part of the legal frameworks of various jurisdictions. Now, courts routinely mandate or even recommend mediation before litigation. I think sometime back when we in Ghana started our commercial law court, mediation became a mandatory requirement, what we call the pre-trial settlement conference before, in fact, litigation. Now we have regional instruments in EU, AU, all introducing mediation and establishing it as a very foundational, integral part of the justice delivery system. Of course, for some of us, the icing on the cake has been the establishment, the passage of the Singapore Convention on Mediation, which then seeks to synchronize mediation at the international level, just like the New York Convention. When you obtain an arbitral award in one country, you can then enforce it in another country. And that has been a major milestone in international mediation, carrying the globalized nature of mediation across board. So officially, it's called the United Nations Convention on International Settlement Agreement resulting from mediation. Now, it provides a mechanism, just like the New York Convention, for enforcement of cross-border mediated settlement. I think one of the attributes of mediation, which I found now in most jurisdictions, and I found it in the Mediation Act of India, is also in the Ghana Alternative Dispute Resolution Act, that a settlement agreement that is arrived at, that is reached out of mediation, is enforceable in a manner like a court judgment. So then it augments mediation settlement agreement and places it at the same level as court judgment. And of course, why not? If we're looking at different methods of dispute resolution, then they shouldn't be inferior or subordinate to litigation when parties have gone through that laborious process of mediation and arrived at a settlement. Of course, the Singapore Convention is what elevates it globally, that settlement agreements obtained in one country may be enforced in other countries and vice versa. Another introduction now to mediation is what is online dispute resolution, basically. And I see it that a provision also made for that in the Indian Act. We don't have that in the ADR, but of course, it's one of the best practices now, particularly post-COVID-19, where there is the introduction and adaptation to online dispute resolution, including online mediation. So quickly, what are some of the key attributes? Having said all of that, mediation is assisted negotiation. As a mediator, you don't negotiate. I mean, if you are even negotiating, which side are you negotiating on? You only assist the parties themselves to negotiate, or you facilitate the negotiation. One of the key attributes of ADR, including mediation, is party determination. The parties who have brought the disputes to the court have control over the process, including who would be their mediator, including the rules, including the policies they want to regulate the dispute resolution. I think in my early days as a lawyer, one of my neighbors who was engaged in litigation will tell you that, lawyer, you go to court and sometimes you are wondering if it is your case they are talking about. Then the lawyer is saying non est factum, and this one says in quote non habet, and they are quoting all these Latin, and I'm thinking, but I just brought a family matter. What is all these Latin languages and all these complicated legal words you're using? Now with ADR and particularly mediation, parties are part of the process. They in fact take the front seat, and it's not being controlled by just lawyers and judges. And sometimes you wonder if it is actually, they actually recognize or appreciate your perspective and what you desire, particularly if you desire just some apology, if you just desire that the commercial relationship you have with the other party is not severed. And of course, lawyers, we also have a whole shenanigans. And of course, we sometimes take the dispute from the parties, we mangle it, and we do whatever we want with them. Parties can feel quite alienated from the whole process. So as a mediator, you're only a facilitator. You are not a negotiator yourself, and you are not a lawyer for one both side. And I really emphasize this for lawyers who are usually playing the role of mediators or even as counsel to one of the parties in mediation. You really need to put your lawyer hat back when it comes to mediation. The mediator does not impose the solution. We heard about that from the various definitions. And usually a mediator must have certain skills, active listening skills. Your communication skills must be top-notch. Of course, it comes with experience, it comes with training, you learn about that. You should be able to help parties to separate their emotions from the issues, help them to identify what we call interest. And of course, normally when you do mediation, you find out that a lot of it is built up on what we call interest-based negotiation, where interest-based negotiation, parties are encouraged to not focus on their position, but their interest. And so if you're a mediator, you want to encourage that sense of negotiation. The parties help to separate the people from the problem, their emotions from the issues, identify their interest based on their decision on some objective criteria, among others. Mediation is voluntary. You remember the definition in Ghana, for instance, non-binding. You can't force a party to mediation. Again, let me put a footnote on that. Some statutes, like the Ghana Act on ADR, there's a requirement where a court can order you to go for mediation. If you look at Section 64 of the ADR Act of Ghana, for instance, but it cannot force you or compel you to take a decision at mediation. So again, when we say that mediation is voluntary, it still does not leave that voluntariness where there is a court mandatory mediation. Mediation is private. Nobody's in your business, just the parties and the mediator. At best, their counsel are there. It's confidential. A mediator is supposed to have one of these key ethical attributes to be able to be to keep things confidential. And I like to put it bluntly, you can't be a gossip and a mediator. And I just like to put it that. Of course, mediation is without prejudice to parties' rights and liabilities. If they are unable to resolve the dispute, there is no if and buts and who caused it. When it goes back to litigation, for instance, or arbitration or any other form, there's no blame game. There's no, it doesn't stop you from, having different position and using different methods when you use other forms of dispute resolution. So there's party submission. How is the process of mediation done? Parties themselves can decide we have a dispute, let's go for mediation. And this can be quite unusual. There's also that court referral where courts may refer parties to mediation. There's also statutory mediation for a number of jurisdictions. Find out that depending on the dispute involved, there's the act, the law regulating that dispute requires party to attempt a settlement through mediation before they look at other adversarial method. One key thing of mediation is the opening statement of the mediator, which is key, which sets the tone, the rule, the ground rules that will be used in mediation, among others. And then the negotiation takes place. Hopefully the back and forth, it's not about legal rights when it comes to mediation. It's about what works for the parties without necessarily assigning blames and rights and liabilities to the various parties. And thankfully, parties are able to settle. Then they draw up the settlement agreement with either themselves or with the assistance of counsel or the mediator. And then there is that enforcement of the settlement agreement. So differences, mediation and litigation. There's always a third party. Litigation, the third party is called the judge. In mediation, the third party is called the mediator. But the role of the third parties differ. The judge imposes a judgment. He looks at the evidences, he looks at the fact, he applies the laws, and he says, you are wrong, you are right, you need to pay this, you need to pay. A mediator does not do that. There's no basis for going into rules of evidence as strictly as litigation. It's about discussion and what works for the parties. The mediator uses his skills, listening skills, to assist the parties themselves. So the parties themselves become the judge, not the mediator. Mediation is amiable, unlike litigation, which is adversarial. It's so much adversarial that sometimes your client even expects you to have a dispute with the lawyer of the other client. They don't expect to see you laughing with them, forgetting that you probably were a law school mates. They expect you to be as adversarial as they are with the other client. There's the voluntariness of mediation. I think I discussed that already, and it's very informal, very flexible. I mean, we can't overlook the tension, the intimidation of the court system, and the fear that people even have when they go to the court system. The procedural rules, unlike mediation, where it's flexible and informal. Of course, even in litigation, if you do not comply with Ghana, for instance, the High Court Civil Procedure Rules, your application can be thrown out. Not because the substance of your matter is weak, but because you fail to comply with the technicality. And of course, the litigant is thinking, I just brought this simple matter. Why do I have to file an application instead of a petition? Why do I have to do disclosures? All of these things can be quite burdensome for a disputant. But the good thing is that the outcome of both, whether litigation and mediation, as I've already explained, is that they are enforceable in the same manner as a court judgment. Then mediation, arbitration. Similar. Arbitration is quite similar to litigation, except that there's much more party autonomy and determination because the parties determine who will be the arbitrator. Of course, there's also the adduction of evidence and rules. The arbitrator bases his decision on evidence, rules, the standard rules, either because the parties have indicated they want to be bound by particular rules, institutional rules, etc. But both of them are voluntary. The effect of both of them is that they are enforced in a manner of a court judgment. The similarities between mediation and arbitration is the privacy of it, the confidentiality of the whole process. And of course, parties are able to decide, we want this particular person to be a third neutral party. But the arbitrator gives a decision like a judge. He imposes a decision on the parties called an arbitral award, and is enforceable like a court judgment. Another good thing about mediation and arbitration is the parties determine who will be their third neutral party based on, for instance, the expertise of that third neutral party. In some jurisdictions, you have one judge, a master of all thing, family, commercial, you know, so they don't build that necessary expertise necessarily in that subject matter. But we can decide, okay, this is an engineering dispute because it was a collapse of a shopping mall. We're going to get this renowned engineer who will be the arbitrator, who will be the mediator to appreciate, the perspective of the dispute. Finally, why are we all about mediation? Because of the disadvantages of that adversarial dispute resolution. I've indicated to, yes, we may have a commercial dispute, but I want the commercial relationship to be ongoing. Of course, the nature of litigation is such that the outcome of the litigation when the judgment is given is that that commercial relationship that we have may be disrupted. That family relationship that we have may be disrupted. That neighborliness relationship that we have may be disrupted. Because dispute litigation basically looks at you are right, you are wrong. But of course, mediation is looking at not who is wrong, but how to mutually come up with an outcome that is beneficial to both parties. It saves time and energy. Of course, I don't think it's just Ghana alone. In India, and the number of years that it takes for judges to deliver, because again, you can't really blame them, because if all of us take our disputes to court, sometimes they are human. They are inundated with all these briefs they have to deal with every day. So mediation saves time and money. There's procedural satisfaction. In mediation, it's not about I put it to you and non est factum and you didn't file a petition and court 9 order and you are wondering, a layman, what is it they are talking about? In mediation, we're talking facts. We're not talking evidences. We're talking things as we know it as layperson, comprehensible to us as a party. The unfriendly court atmosphere is taken out when it comes to mediation. Primarily, substantially, the satisfaction of mediation outcomes is mutually decided. And of course, if it's mutually decided by the parties, the probability that it will be enforced or complied with by the parties also becomes high. Unlike court system, where the court gives a judgment and even enforcing that judgment becomes another headache. You have to now be chasing the party for properties they have or other things to enforce the judgment. And of course, top on it for me is that mediation helps to preserve relationships because it breaks down that barriers, communication barrier. It breaks down that egoistic, tendencies that we normally see in court. It breaks down that adversarial nature that we see in court. And finally, there's enormous party determination in mediation, unlike litigation. If I file a commercial case right now in court in Ghana, and I believe in India and all other, I don't know which judge is going to sit on it. Whether the judge is knowledgeable in the area, I don't know. I don't know which courts, because there are a number of high courts. You are at the mercy of the system. But with mediation, you, the party, determine a number of these things and how you want things to go. I wish there was more time, but I'd like to conclude by saying that mediation has seen a trajectory that for us in Ghana, there's something we call sankofa, literally meaning go back and take what you had before. The trajectory has been that we're going back to what we knew in our justice delivery or dispute resolution system. And now mediation has moved from community-based tradition, which were in different countries, and it's become now formalized, it's become now institutionalized, and it has also gained global prominences. In fact, what we see demonstrated by this training by Nivaran is that mediation has now become a preferable rather than an alternative mode of dispute resolution because of its advantages. Thank you very much.
Thank you. Can we move the slides from here? Tell me how to, Shantan.
Yeah.
Is there any question? Can I see any question in this thing? But before I take up the questions, Diana, I must say that you have so nicely and successfully just held our hands and taken all of us through the journey, beautiful journey from what you say that a community sort of facilitation.
Oh my God, have I missed you?
Hello. Hello. Is there any problem?
We can hear you. Go ahead.
Okay. So how Diana has took us through the fact that all ancient civilizations' default resolution process had been mediation and conciliation. And in India also, we have seen that there is Samvad due to its nature of malleability. And then with the example of a hospital OPD, she made us think about the concept of one size does not fit for all. Why only looking at litigation at the only panacea for all kind of disputes? So that is there, and then we can see that how the community-based dispute resolution system slowly developed into more formalized into an institution in itself today, the mediation. So but I think we have lost the connection of Diana.
No, I'm here. I'm here. I can
There? Yeah, okay.
yeah.
So with your permission, can I ask that if it is correct to participate in mediation wearing the hat of a litigator?
All right, thank you, Sangeeta.
Yeah.
Would you want me to answer as and when the questions come?
No, this is a question I am asking from my own side, because now I can't see anything, any questions has come in the chat. Is there any?
Okay.
Yes. Okay.
So again, my answer to
there are
Sangeeta
questions.
will be that
Yeah.
it depends on the perspective that you're playing. If you're a litigator like myself, I mean, I still practice in the court, and you are a mediator, you have to continuously remind yourself that you are not a lawyer. You are only a mediator. And so in as much as your mental faculty is telling you that, oh, this party may be wrong, you have to be consciously aware that you are no more a litigator as a mediator. You have to be consciously aware of your role, that you only facilitate. You don't impose solutions on the parties. Because I've told you, people come to mediation for different reasons. Some come not because of monetary compensation, but he just wants you to recognize your wrong and just apologize, for instance. And you are sitting there as coach and you're like, oh my God, if you are taking this matter to court, you probably will get $10,000. So you are pushing for something around that. That is not what parties want. Because the adversarial system gives you forms by which resolution will come up.
Yes.
No, I don't want compensation. I just want you as my neighbor to recognize that you wronged me. And that's all it is about. So you have to be conscious as a lawyer. Of course, if you're also a lawyer for one of the parties in mediation, again, in the beginning, a lot of lawyers didn't understand the role they play as counsel to a mediating party. They still bring that adversarial system. And thankfully, what we did in Ghana was to train the lawyers to also appreciate their role in mediation. That you let your client take the lead. You let them own the process. You only guide them as lawyers in that mediation process. You don't put it to us in mediation. You are not citing and holding rigidly onto rules, because that's not what it's about. It's an informal process. We're looking at workable solutions without necessarily it being a legal solution. So yes, you can be, but it needs a lot of conscientization as a litigator, depending on the role that you play.
Okay, thank you. There is a question I can see from Mr. Surya Narayanan. Parties view and approach the courts with the belief that they are the authorities who can provide justice and prove their right. How can people be convinced to trust alternative dispute redressal system over litigation at this juncture?
Right. For me, it's a very important question. For me, I think one of the good things jurisdictions like India and Ghana have come up with is the nature or the enforceability of the settlement agreement as the outcome of mediation. So that is not, because we are saying it's informal, it doesn't necessarily mean that the outcome will not be respected. For me, it was a key thing. If you look at Ghana's ADR, Section 82 is there. It's enforceable like a judgment in the court. Then you get the additional value of privacy, Nobody is in your business in the mediation. I can walk in any court right now in Ghana and hear any case about anybody because it's an open forum. So the added benefit beyond the fact that it's on the same pedestal now as litigation is that the outcome is enforceable and much more. You get extra benefits. You decide. You may not particularly like this judge, and it's not personal, but you feel that he's not strong in a particular area on commercial law, on oil and gas, but you have no choice. Your matter has been put before the judge. Get a mediator who understands, who is guiding, drawing your attention to certain key issues like interest, certain key issues like the objective criteria. What would a reasonable man do? What would the court's outcome be? To draw your attention to these things. You get the benefits of confidentiality. Again, that you don't get the things that are discussed and very, some trade secrets. People don't want it out there in court as exhibit. Then they announce the exhibit and the clerk shows the whole exhibit to everybody. It's probably your trade secret. So how to encourage people is that you get the same deal as you do in court to be able to enforce your settlement agreement, but you get extras. And the extras is that I would want to be confident that Sangeeta is discreet enough, is an expert enough to appreciate the dispute and help all of us to avert our mind to the issues that need to be dealt with and resolved.
Thank you. The next question I can take up came from Siddharth Patra. How effective is the pre-litigation mediation model in legal systems, where mediation is also frequently initiated during or after trial, particularly at the appellate stage? Does resorting to mediation in the midst of or after a verdict undermine the predictability and finality of litigation? Or can it serve as a legitimate tool for negotiated justice even after adversarial proceedings have begun?
Right. So, Sangeeta, that's a very good question again. I like to say this often, that even in a dispute where one person has 100% good case and the other has a 0% good case, or a weak case, 100% weak case, there is still disadvantage with the adversarial system. The time and the money and the expenses involved, you can't overlook that. There are cases in Ghana, examples, I'm not happy to say that, 20 years, minimum, 3-5 years, 24 years. There's a case my own boss started and I had to continue when I became a lawyer. He started it as a lawyer 24 years ago. I had to come and I got the brief. I was also chasing the same matter. So even if you have 100% case, there is that difficulty of the time and expense. Even if you get a judgment, again, when you get a judgment, I keep telling my students, that is not the end of the matter. Sometimes the enforcement process alone will take more years than the years it took you to get a judgment. So if you get a judgment, it's so possible for parties to come to the mediation table and look at the way. Of course, you have a judgment which puts you on a stronger edge, but you want to go through the expense and the time and fishing out for assets and property. Sometimes the assets are not even in the jurisdiction. You have to travel, which I've done a number of times. The drudgery of it, we are traveling to London because the account is in the UK just to go and enforce this. Why can't I sit down, even with the judgment in my hand? You know what? I have judgment, all right, but can we sit down and talk about this? Are you able to do it in installments, or rather than me hiring lawyers, going across borders to even go and trace your assets and then enforce them? So I always say that even when you have judgment, mediation becomes important, because getting the judgment is not self-enforcing. Sometimes it's even extra difficult to enforce the judgment.
And I think it's like pre-litigation, or as you said, pre-trial mediation. It always nipping in the bud the dispute.
Yeah.
So it is much more, nurturing the relationship. It is much more beneficial.
Yeah.
Next question. In what ways can mediation become ineffective despite being less adversarial than litigation? I am reading out again.
Right.
It is coming from Laudio Lupita. In what ways can mediation become ineffective despite being less adversarial than litigation?
I'm happy this question comes because it will be very oblivious on my part to sit here and suggest that mediation is 100%. It hasn't got its own challenges. Of course, there are certain situations where you need, for purposes of establishing precedent, for instance, is a new area, there needs to be a court pronouncement on it to guide future interaction. So in that case, it may not, in criminal matters, even though there's some sense of victim offender mediation now, but sometimes for the deterrence nature of some of these offenses, you will need mediation, then becomes ineffective. But largely, I think that the advantages or the percentage of the effectiveness of mediation outweighs the ineffectiveness. Of course, you can have a mediator who may be biased. I mean, you can't take away from it. That's why there's the admonition to mediators to be wary of these attributes they need to possess. The issues can drag on and on. It can be very emotionally high, the whole process, which makes it ineffective. So clearly, again, I'm happy for this question. It will be very oblivious on my part to think and tell you that, look, mediation is 100%. There's nothing wrong with it. Sometimes for purposes of establishing precedent, for deterrence purposes, mediation becomes ineffective. You need to make a strong statement by the adversarial system.
We are running out of time. The last question I will take, it has come from Surjit Ali Zakir Ali. Please explain the role of a mediator in short. Of course, it's a very broad spectrum question. Role of a mediator. What is the role of a mediator?
So your role really is that you're a facilitator. And I think I always want to extend that by saying that, look, you need to appreciate, first of all, your role as you are a catalyst in the whole justice delivery system. You need to appreciate your role that you are aiding parties not to go and join the backlog of cases that we have in court, for instance. And your role is that you have a better view of disputes where you know, first of all, disputes are resolvable. And not just resolvable, but they are amicably resolvable. And there's a win-win situation. I've told you, even if you have a strong case, why would you want to waste 5 years of your time in court? That gives it about -2% of your 100% strong case. And that is where I always proceed. Even for me as a lawyer, when I started embracing AD, I felt that I would rather move on quickly with this case through mediation, move on to the next brief and make the next money out of it. So I always want to encourage, your role is that you have various roles, but you're a facilitator. And your facilitation should aid the justice delivery system. Your facilitation should aid the peace, particularly if you're a close-knit community or you are in a community where relationship preservation is very key and that is your role, and you have to have that. That should be the broad mind with which you roll and help parties to come together. Normally because they can't even talk to themselves. So you help to break the ice. There are a number of skills you learn when you do these mediation trainings to help them to communicate as a first step and to arrive at their own dispute resolution. Thank you.
Diana, this one I have to take from Amrita BN. Most probably she is in love with your country. What is the career possibility in Ghana with respect to mediation? Asking the question as a law student in India, she has written. So
okay. So I mean, again, I was one of the pioneer lecturers that introduced ADR to the university. And I was amazed at the response of my students because they realized that even as interns, they had witnessed going to court back and forth and just getting adjournments, dates for adjournments, and nothing really happens. It gets boring at a point. And so in Ghana, you see more people are embracing ADR. I mean, I don't like to say this with pride, but particularly for most people don't like litigation, but we are encouraging that they don't, because the adversarial nature of the heated nature of litigation, people would rather, stay off from litigation. And I believe it's probably the same for India. We realize that now a lot more students are being encouraged to look at not just donning your robe and gown to go and say, I put it to you, but looking at short term, how they can resolve dispute. And look, it is no gainsaying the fact the joy you receive when you help parties to resolve their dispute within the shortest possible time. And let me be selfish a bit. You get more money as a lawyer. And I keep telling lawyers, because when we started, they were very opposing of litigation. They said, look, I don't want to be in court for 20 years like my boss did, fighting over a land for 20 years. And then I'm stuck with this case and charging probably, if you're not doing hourly billing, which we don't usually do because people can't afford hourly billing in Ghana. So you probably take a lump sum, you've taken $2,000 and you are stuck with this dispute for 20 years. I don't want to do that. I want to finish off in a year. I want to move on to the next brief and I want to have another compensation for that. So there are so many prospects, especially when we speak about the benefits of mediation.
There are so many more questions I can see, but I can see Mr. Manoj Mathur raising his hand. So,
I mean, I have time if you do. I mean, but
what do you say, Santana? I go by your decision. There are another. I can see it's so many. There are 64. I mean, we cannot take up all the.
You can fix it to about 3 or 4 questions.
3 or 4 questions. Mr. Manoj Mathur, you are muted, sir.
Are you able to hear me now?
Yeah.
Thank you for taking my question. Diana, this is really building further on the hospital example.
Yeah.
A very interesting example. So do you see specialist mediators coming up progressively, that is experts in healthcare disputes, construction disputes, software, IT, and lastly for disputes where AI, artificial intelligence itself is in dispute or in conflict with natural persons in the next maybe 5 to 10 years, since there is a complexification of disputes progressively taking place due to advancements in science and technology. I just want to, pick your brains on that. Thank you.
No, absolutely, I agree. I mean, defaults, we don't. So normally when we say these things, then you have lawyers saying, but so I can't be a mediator because I'm not a lawyer. And I say, no, that's not the case. But it gives you better perspective. If people are area specific or area experts in a particular construction, we see a lot of these coming up in Ghana now. People are taking particular niche. People are being identified, just like arbitration, as having expertise in a particular dispute when they go for mediation. I think long term it's very beneficial, but I always say that is not a total exclusion if you don't have the skills, because in our mediation law, and I believe the same for India, the mediator with the consent of the parties can get an expert to assist the process. But I think for you, it helps to cut down the cost. Now we're moving into AI discussions, if you're knowledgeable in that. And of course, for you as a mediator, you don't become a jack of all and master of none. You become, not because don't forget that, like we established here today, you don't decide or make a decision for the party. But when it comes now weighing the various options in mediation and use objective criteria. If I'm an engineer expert, I can understand more why some of the options are coming in, which are workable, short term, medium term, long term. If not, what happens then is that as a mediator, I may have to postpone the session and go and seek that advice from outside. So it's good. I think we are gradually getting to the stage where we should build. And in fact, people have already started building expertise in particular subject area. So yeah, absolutely. I would encourage that, yes.
Thank you. That's helpful. Thank you.
And here also we can co-opt experts in the mediation processes, if I'm not wrong.
Yeah.
There is one question I'm taking from Dr. Padmavati. She says, what is the success of mutually agreed settlements? Are they really implemented in true spirit? Need for enforceability of agreed settlement. So she was there.
Right.
Yes, you can.
So yeah. It's so unfortunate I don't have the statistic. We just finished celebrating our ADR week, I think last month, where the judge in charge of ADR gave a number of statistics, which were very encouraging. And again, I like to say this. When you reach the settlement agreement, it cuts the long process for you. because you've probably been able, I've seen mediation. I think yesterday at the opening ceremony, I think one of the gentlemen from, is it Singapore, indicated that he was in the middle of a mediation session. They started in the morning at 9 a.m. They were done by 6:30 p.m. I don't think you have that. So for me, that knowledge that I can have this in a day, I can have this in 3 days and 6 months, and then it cuts that long process of minimum of 3 years in court for me, or up to 20 years in court for me, and then puts me at a level where I now only need to go for enforcement, is key. You can't take away the fact that some people may have a change of mind even after they have settled the mediation, but it's rare. Because you know why? They themselves decided and agreed with the parties how they want the matter to be raised. So if it is installment payments, they are looking at it. And that's one of the advantages, because parties themselves decided, whether intentionally or egoistically, they will enforce it. But you can have a few, bad nuts who now have a change of mind and decide to give you a tough time. But then you use the same court process to enforce it. But it gives you that advantage that you've cut short the process by which you are. I'm yet to hear of any mediation process that has taken even 3 years before. I haven't. I don't know if it's happening in India. It's either parties were unable to resolve, or if and when they were able to resolve, it was shorter than the minimum it takes to resolve a matter in court. And we've seen an example yesterday. It took barely 12 hours.
Thanks,
Dr.
ma'am.
Padmavati, you want to ask?
Yes, ma'am. I just wanted to thank the madam first. And secondly, always it's bugging in my mind, regarding we file EPs for implementation. The madam has both in Ghana as well as Indian Mediation Act, the enforceability clause is there. So only thing is, if at all we needed to go for that enforceability, so again we'll be end up with the same kind of process. So the madam clarified that the whole thing takes place 3 years. So definitely it's much better when compared to the litigation, no doubt. But still keeping fingers crossed regarding the TP part.
Want more from mediation?
Yeah. Thank you, ma'am.
Yes.
Sure, thank you.
Yes, Diana.
Yeah. So, I think we're saying that it's not absolutely immune from some of the disadvantages, because whatever ADR process that you really have to come back to the court and actually enforce. I think research-wise, we see more people complying with the terms of the settlement than we see them not complying back to court. And the data I have from the end of Ghana, because of course they said, well, I'll pay in 10 months, I'll pay in 12 months, and then it's running. But you can't take away the fact that sometimes you have to end up going back to the court. But the breather for you is that you don't have to now go and adduce fresh evidence to start the whole litigation process. You now come back to the stage of enforceability. And I think that is still advantageous, no matter how you look at it.
Thank you, ma'am.
There's one question from one final year law student from Symbiosis Law School, Noida, India, Mahek Gupta. She is saying, in trying to globalize mediation with uniform rules and procedures, do you think we risk losing the cultural identity or effectiveness of local models of justice? Very good question. And how can countries like ours protect that balance while still promoting mediation internationally?
Thank you very much. That question doesn't sound like it's coming from a law student. It's quite interesting and quite loaded. For me, I actually rather encourage the globalization of it. And I'll tell you what, as a student myself in ADR, I remember we did the aspect of ADR where we looked at cross-cultural perspectives or culture. We started with the cultural perspectives, then we did with the cross-culture. It was highly illuminating for me. I think one of the trainings that any mediator will have is to be aware of the cultural tendencies or the cultural considerations of that particular dispute. And you find out that culture as they may be, research will show that they are not enormously diverse. They are quite similar. And for me, it helps to, even for the mediator, you learn different cultures, you learn different ways of doing things, which may be helpful in another context, in a cross-cultural setting. Learn to pick best practices, as we call it in the formal system, So I rather much more encourage cross-cultural and globalized mediation. And I see that coming up a lot now. Just like arbitration, you have arbitrators coming from different jurisdictions. They may even come from civil law countries, common law countries, but you realize that the workable solutions may be adopted from one particular cultural context for the mediation. And you find out that parties may pick that option that may be floated to them as an ideal situation. Of course, culture is dynamic, and I rather encourage it, but you have to be wary of the peculiarity of the cultures that people are coming from, not eroding it, but it's also helpful that we be open-minded to adopt other culture. I'm looking for it very globalized, international, commercial disputes where you have perhaps 3 mediators or 2 mediators co-mediating with very knowledgeable and broad cultural perspective to actually bring the parties together.
Now, Diana, how important is a counsel in a mediation session? The question comes from Arjun Krishna.
Right.
J. Arjun.
It's a very dicey question. You know, I have a personal view. When my clients have to go for mediation, I hardly go with them. What I do rather is to educate them on what mediation is about, that nobody can compel you to take a particular decision. Is a party autonomy. Of course, you have to be courteous in the whole process, but I want you to own the process. But of course, some clients still always, because they have your retainer agreement, they still feel protected when their lawyer is following them to mediation session. The role of counsel is very important in various ways. So as I sit down and I'm hearing my client in mediation session recount how he feels about it, the emotional bit about it, the interest, and particularly at the stage where options are generated by both parties. That is where the counsel becomes very relevant. And you may meet with the client and tell him that, you know what, you want to pick this option that has come up and run with it. Because if you're going to be in court, we're not going to get this particular type of option that has come to the table. So for me, I sit back because I want people to vent, my clients to vent, to be part of the process without being a litigant at the process. So people have different views, but I personally, I just don't like to accompany my client unless they insist. And I tell them that, look, as a counsel, I am not going to be the one to do the talking. I'm only going to guide you so that if the process is gearing in a way which is not healthy for both of you, I can tell you. But I like to sit back and watch my client. So I won't discount the role of counsel at all.
So am I hearing that you really prefer that the lawyers should come after the parties are duly empowered by the mediator about the mediation process, and then comes the lawyer's role?
Yes, for me, that your role is like a support, like a back support, really. They are the front, and they are venting, and they are owning the process, you know, and then sometimes you let them do the evaluation of whatever options is on the table to tell them, like, we are not going to get this anywhere in court. So the earlier both of you decide on one of these options, the better for you. And of course, you, the lawyer, it also helps you quickly resolve it and move on to the next case.
So I think we have got 10 minutes extra from Diana. So here is the time. I think I should wrap it up. What do you say, Santan? Okay. So I think most of the relevant queries, I will not say the most of the queries because there are so many, but most of the relevant queries raised here had been taken up today. I thank Nivaran team for giving us such wonderful opportunities each year to interact with the renowned professionals from all over the world through such events. And Diana, I must say it is wonderful to have you today in this great session. Absolutely wonderful. You are so forceful.
Thank you very much for thanking me. I'm also going to use some of the questions to ask my students in class. So I've also enjoyed it, and I've also learned something, particularly questions to ask my students.
Send the questions, the queries to Diana. I don't know.
Yeah, I'll use them as exam questions.
Yes. So it's been a pleasure exploring the benefits of mediation with you and hearing your insights and experiences. Mediation is not just about reaching agreements, but also about understanding perspectives, building relationships, and finding mutually beneficial solutions. So the key takeaways are to reap benefits from mediation. We must follow its different stages with a clear understanding of one's own objectives. There must not be parties sitting with an agenda. That is the most important thing. To remain open to alternative solutions and communicate effectively, to apply what we all learned in our everyday interactions. This, in turn, will transform our strife-torn world to a much better place to live in. Traditional litigation or the adversarial system, though essential for delivering justice in many situations, has several lacunae and limitations. As we all know, courts often have limited flexibility to tailor remedies that meet the nuanced interests of the parties. These underscore the growing importance of earlier processes like mediation, which offer speed, economy, confidentiality, and creative solutions. Mediation fosters understanding, preserves relationships, and empowers parties to take control of their disputes, qualities essential for a more humane and efficient justice system. Thank you again for your engagement, Diana, and thanks all the participants and the wonderful questions you have asked. I must thank all our senior founder members who silently strive for the betterment of Nivaran and have truly become the backbone of Nivaran and brought it to this height. Finally, thanks to our IT persons who helped us to reap the benefits of this wonderful session seamlessly without any technical glitches. We will wait for you all tomorrow at 5 p.m. sharp, where you will have Mr. Jitendra Mohan Sharma, Senior Advocate and Mediator, Supreme Court of India, as the guest speaker speaking on the topic online mediation, advantages and disadvantages. And Ms. Sakshi Banga will be the host and moderator. So thank you and adios. I think it has been a wonderful session and we have really benefited from it. Thanks. Thanks, Diana.
Thank you.
Thank you, Dana. Thank you. Thank you,
Diana,
Sangeeta.
thank you so much.